how is everybody?
Great.
You're in the middle of the semester. It'd be great, you know. It's not like you have any work to do or any jobs to get or anything like that. So it should be a very low pressure time. So let me try not to add to your woes this week. We did change our guest speaker because we had a technical glitch, and he was going to come to us from London, England, and there's a new system that UBC is using to do remote, and there wasn't time to test it properly. So Jazz Purewald will join us later in the course, and Mavis Dixon, who's quite awesome, is going to talk to us about, on the surface, the issue of games that are known as serious games, games that promote health, that sort of gamifying people to do good things for themselves. The subtext of it will also go into issues of addiction, because if you can get people to change their behavior, the same mechanisms that get them to change their behavior for good can get them to change their behavior presumably in any way you want. So it's an incredibly important and interesting topic that will become increasingly relevant to the balance of the course. Any questions on anything? At this point, I'd say I've heard from at least half of you on papers. I owe a few emails here and there, which I will get to today. But I feel like I've talked to about half of you one way or another. So we're probably getting to that time over the next 2 weeks or so where it would be good for me to I'll create a list, check off that people have talked to me, and hopefully I'll be on top of that. So I've got a few housekeeping things. The first is that a couple of weeks ago, this course was invited into the UBC Badges project. This has no impact, certainly not this year, on marks or grades or anything to do with anything, except you might find it useful. There are badges, and I think they'll be redone in a fancier way. Here's where you can go to find out about the UBC Open Badges project. And basically, there's no subjective element, because I didn't want to have any subjective element to this. It's all objective. If you post once on the website, you get a subscriber badge. If you create a post and leave a comment, you get a community badge. 3 comments and 1 post is a contributor badge. 10 comments on posts and 5 posts of your own, you're a creator. Hopefully, we'll create some variance in all of this. UBC is working on an infrastructure so that you can actually take badges and put them on your CV, and they're always accessible to you. So it's built in, no one has to do anything, no one has to use it, and it is not marked. Now, having said that, to be clear, the mark around participation, I do look at what's been contributed to the website, but it won't be through the badging thing. It's very easy. I can click on your name and see what's there and what isn't there, and I kind of go through it in a very systematic way. And again, just to be clear, I tend to be interested more in people participating and commenting than this has to be a long and thoughtful post. Your long and thoughtful piece is really meant to be the paper, and participation is participation. And I'm not saying quality doesn't matter at all, but it's just not the primary piece of the assessment. Quality becomes very important, obviously, in the paper where it should be. This is very cool. There are 4 courses that are doing this. We are actually, believe it or not, even though we joined the project like literally 3 weeks ago, where we were invited in by UBC, we're the first ones actually up. So how that happened is unclear. This is a bit of a surprise to me, and it's a bit of a positive thing. And I think it may be useful in some way to your papers, but it also may be useful to you long term. Even though the 2nd edition of the book is out there and you have it, and even though LexisNexis has asked now for a 3rd edition of the book, I went to them, and maybe because of that, I went to them and I said, could we get the 1st edition of the book and put it up holus bolus on the wiki inside the course website, so it can be used by the students, added to by the students, manipulated by the students, and it's completely open to the world. But would you consider releasing, because the way it works in a publication contract, even though I wrote this book, I don't actually own, we'll be talking about this today, I don't, by contract, own the intellectual property. The publisher does. And much to my surprise, I got an email last night saying, sure, go ahead. So I need to talk to them about, can I get their proof? Can I get, because this is sort of an aside, and an interesting aside, perhaps, since we'll be talking about contracts today. I never got a Word version of this book after they had gone through it. So I don't have this. I have the last Word version of what I submitted to them, and then I have page proofs from them that I mark up and send back to them. So, publishers were very conscious of their intellectual property because it's an intellectual property transfer agreement. I agree to transfer it to them for the 2 cents a book that I will get in perpetuity, which I think now has added up to $1.60. It's not that bad, but it's pretty close to it. No one writes a legal text for money. Anybody, it's just, completely, there's nothing in it from that perspective. There's lots of other stuff in it. So it's really nice, and it's still plagiarism if you just lift stuff from the book, but the point is it's there and it's going to be in manipulable form, and it should make your life easier, which to me, now it only goes to 2005, but for all the early stuff, all the origins and history of video game law, this is still the basis of this, and now you have it in easily manipulable form, and it's not, I think, in fairness, all the stuff is available on the internet. You can find case briefs in various places, but this probably becomes an easier primary source for you. So that's very cool, and I'm very determined to try and get this up in the next week so that you actually have it in time. And then the other thing is, I don't know how this will work. I'll work it up with CTLT, but you can also comment and add and do whatever you want for posterity, and it will stay. So we're just wikiing the book, in a sense, co-authoring it, moving forward. And then, because I do mention you guys, I am on the cover of Canadian Lawyer this month. I do mention the course. If you're interested, you can read the article. I do talk about jobs in the video game industry and what that looks like and doesn't look like. And we'll move off of that as quickly as possible. It's like a conspiracy. Come on. Seriously. Okay. So, I'm afraid to go back. So yeah, we got a little philosophical last week. And I will try and manage that into a clear and coherent form going forward for the next 10 or 15 minutes. I don't know if anybody has seen this, but to me it's one of the funniest bits that Monty Python ever did. Anybody ever see the Greek versus German philosophers soccer match? Okay, so yeah, the more geeky among us, totally worth your 4 minutes. And there's a link there, and I put it in as a self-mocking reference for what happens when you get too philosophical. Having said that, I am unrepentant. So, the real question, let's assume that what I stumbled into last week is correct and video games are post-structuralists, so congratulations, gee whiz. Yes, we used to think that what made digital media different was that it's interactive. You've perhaps shown that by using Derrida, interactivity actually means that the balance of creative power lies with the user, the gamer, and maybe there's some other implications. Well, if the model is correct, and I'm increasingly believing it is, but you'll decide for yourself, there are legal implications, serious legal implications. And today we're going to just go as far in the next 10 minutes as identifying where those legal implications may be. And there may be more, and you may add to them, and that would actually be awesome. And then in the last talk of the year, I will probably really drill down on the list that I'm about to give you. And I'll probably give a lot of hints around. So, just a reminder of where this started, if you're looking for a reference point. And I'm going to kill this thing. Break it. I did something interesting because I said to you that I had stumbled in this and others must have thought of it. I can't believe that this was a brand new idea. And in fact, I was right. So here's a Google search on video games as post-structuralism. And there were a couple of pieces in 2010 and 2011, which I will show you. And what's really, really frightening is that a post from last week, from like Thursday or Friday, posting the video of the course and of the class and mentioning post-structuralism ends up being third on Google. So yes, it's been thought of, and no, not much. And then I thought, oh, well, surely the same principles apply. So a whole bunch of people have done work on post-structuralism, and video games is too narrow, and it's really hard to get at. I've been doing this for, this is the 8th iteration of this course, and I just figured this out. So this can't be that, I'm not that smart, but this can't be that easy. But somebody for sure has looked at it and looked at it in terms of post-structuralism and copyright, post-structuralism and IP. It's so obvious, same principles. Nada. Nothing. Forget this scholarly articles thing. These are Google scholarly articles, and they do mention post-structuralism, but they're not on point. And then you're you're at encyclopedia.com. So this may be because I'm just way off the mark, or this may be because this is just really difficult stuff. And I'd like to think that it's because it's difficult stuff. So what do we have? We have some very good pieces that are posts, not scholarly articles, but are almost there, that say, you know what, video games really are post-structuralist. But these are not written by lawyers. These are written by designers, by architects, people who are thinking about the subject. This was a good one. I'll just give you the quote. Post-structuralism with respect to narratology can be said to focus on decentralization of the author and the replacement of them with the reader. This is probably my favorite piece from The Escapist. Again, I've given you links if you are interested in all of this. But this should resonate. The way a text is read by one person is not invalidated by another reading of it, but rather just another interpretation given a different situated perspective. So what does this mean for an individual reader, and more importantly, a video game player? So, let's replace text with game. The way a game is played by one person is not invalidated by the way another player plays it. It's just an interpretation given from a different perspective. You say that about games, it's completely obvious. Duh. So what? Of course it is. But that's why this works. And so if you think about what this is really saying, is in the context of a book, there isn't one way to review a book. There isn't one correct interpretation, because you cannot account for all of the reader's interpretations, and implicitly and to some extent explicitly in post-structuralism, the interpretations by the reader, by the gamer, are more important than those of the author. So, there you go. Decentralizing the author and replacing them with the reader becomes decentralizing the developer and replacing them with the game. Great example is Minecraft. Now, in fairness to Notch, Minecraft is a very conscious example. He, to some extent, wanted to do some version of this, but even he didn't envision what his audience, what the gamers would do with it. So, you know, there's a perfectly good example where you realize you're letting this out into the wild, but when you do, you really do. And it becomes the reader/gamer's interpretation that becomes virtually everything. And Minecraft is, you know, in fairness, the most extreme example of that I can think of. And you've seen this up. And so, have you seen these word alignments? And the point being that there are structuralist elements on the left side and post-structuralist elements here. And these are all words we've talked about, so I'm not going to spend a lot of time on it, but let's see if it's here. There is something I need to add here. And it's very close. Video game needs video gamer under it. And then you see this. And the difference between gamer and game is obviously what we focus on, and Magic and Circle reinforces that. Human and societal reinforces that still. McLuhan is just further reinforcement, but no, I did want to do something specific here. So this is McLuhan in 64, where he says games become faithful models of the culture because of the fact that this is social math, that this is interactive in its very nature. And action and reaction is incorporated into one dynamic image. So again, very, very post-structuralist. The author and the reader, the developer and the gamer merge. And that's why, because of all of that synergy and all of that energy, games become faithful models of the culture, and boom. How virtual gaming worlds are revealing the nature of human hierarchies because they're basically a mirror. So this is real. Boyden, again, systems are shells into which users point. And all the concepts I gave you last week, these are all the gaming concepts that really are post-structuralist concepts. So now, this is sort of a brief review. This is a really interesting piece. I don't know how they did it because it's a lot of big data work. The Museum of Modern Art in New York, for an exhibition called Inventing Abstraction, they mapped, and they did this in a very empirical way, how different abstract artists influenced each other. And this is pretty post-structuralist. There's a pattern, but it isn't a obvious. So, why are we doing all this? This nice little delving into philosophy, sort of fun. I don't find it particularly fun, but I can find it interesting from a games perspective. Is that and you know this from your other courses, if we can find the right ethical underpinning, the right model, then that model gets adopted into law over time. And I'll go through that process either next week or the week after, and why that particularly applies in media, all media, not just games. But that's a little too much to get into today. So if we've got a right model, we might be able to identify legal principles and solutions that are congruent and aligned with the model. So we have to say to ourselves, okay, if we understand games as post-structuralist, if we understand that there's really a merger of what we refer to as the author and identified as the creator with the gamer, user, reader as perhaps the prevailing creator, what legal implications does that have? So what if games really are post-structuralist? How do we assess the laws that we have? And I just want to kind of reinforce one thing, and you may disagree, but this is something I've been quoted on a few times by video game academics, so I've resuscitated the slide because it's obviously important to someone or some people, and it's this notion that ethics comes before law. Ethics has to dictate law. Law does not dictate ethics. And when law does dictate ethics, bad things happen. And think of repressive regimes around the world, and ethics often get subjugated to the ethic of control, which isn't really an ethic. And that's my argument. So ethics comes first. If you have defined a solid groundwork, then you can define what the law should be. So here's the list that I promised. Almost all these concepts you have heard about or will hear about in more detail. And each one of them, and there may be 20, and I'd love to hear from you whether you see other legal issues and legal principles that get brought into this. Where you hold up the law and say, is this aligned, is this congruent with understanding video games as they are, as post-structurals? And the easy one, so I'll just start with the easy one, copyright and mods. Clearly, the law as it was, and I'll elaborate on why I say that, why I say as it was, didn't really accommodate the model very well. The notion of a single author that has property rights in something that most of the labor associated with is being done by others, and most of the actual creative output on balance is done by others. Just doesn't work well in a video game model. Why does it work in a book model, in an author book model? It equally perhaps shouldn't. But I think the reason we accommodated ourselves to it legally better and didn't question it quite as much except in philosophical terms. It's always been questioned in philosophical terms. Is because of the idea-expression dichotomy. When you're reading a book and you're, in a sense, adding to the book in a post-structuralist way, it never ends up being expressed as anything other than an idea in your mind. Now, you can write a review, and as soon as you write a review, hey, that's good. You've got a copyright on the review. And we protect review in the Copyright Act. So we accommodated the primary problem, not necessarily in a principled way, but who cares? It's taken care of. Everybody sort of see that? Okay. But games create a problem, especially these days, but really always. As long as we've had hard drives. There's a expression, and it's recorded. And now it's really recorded. I mean, you could record every second of your gameplay on a PlayStation 4 or an Xbox. You know, every single thing you've done is there. So the expression is there, and the law, so it's easier for us psychologically to go, oh, well, the gamers are part of this. Users are part of this. Now, why do I say the law's already changed? I've mentioned this many times, but I'll mention it again in this context, and that's the Supreme Court of Canada and the copyright pentology. If you want to look at the copyright pentology, I'm not suggesting this is a paper, although if someone wants to do it, you're more than welcome to. You can easily go through the Supreme Court of Canada decision and label it as post-structuralist philosophy. You really can. Because it is the interaction that begets the user's rights. So it's actually pretty clear. And then there's a whole bunch of other problems. all of which can be held up to the lens, and which I'm not going to do today. But trademarks is a very interesting one because it functions so differently from copyright and patent law. You know, and trademarks may, trademarks doesn't, for instance, give you kind of the opposite. Trademarks doesn't strike me as very post-structuralist at all. You add nothing as a user to the trademark. Trademark law perhaps doesn't have to change at all for that reason. As you heard from David Spratley last week, it's really very purely commercial law. It's not user-based. There is no post-structuralist dialectic to trademarks. It's not for the public good. It's not public property, the way copyright and patent is conceived of. So, just to give you an example, you've heard of most of the other things. The moral rights one, I think, is the big one for me. There are strains that go both ways. Right now, when I look at it, I say, I was really pro-moral rights. I'm not sure that it accommodates itself very well to a post-structuralist interpretation. Privacy, however, so we're going to obviously talk about contracts today in part, so there may be some learnings there. But privacy is really interesting, because if you look at privacy from a post-structuralist perspective, the roles are reversed. And the power should be not in the developer or the system. It should be in the creator-user. And the creator-user, you and me, should be dictating what our sphere of privacy is. And it does feel like the law is getting there. But this kind of interpretation maybe in some small way helps it get there fast. Questions on this? All right, that's it. We can now, that's it for now, and I'll try and wrap it up in a nice bow before the course is over. So today we are reinforcing this notion that you will have heard before, and that is that contracts have put us into a post-IP world, and that, in fact, if we want to redress or address many of the issues that we've talked about, and the structural, the post-structuralist reality of video games, even, that they're going to have to be addressed through contracts. And today we're going to look at what contracts actually do and how they actually operate. This is a very realist piece from here on in. This slide, ironically, is something you need to watch equally in a contractual perspective. Because all of these things get destroyed by contract. Like just gone. So what you need to look at is, what does contract law do to copyright? What does it do to the right to create or any kind of expressive and creative freedoms? What does it do to your connective freedoms? And the one sort of philosophical thought is, think about where the power lies. Does it lie with the gamer? Does it lie with the developer? You already know the answer to this. It's the developer's contract of adhesion. This is what's really happening. And this is a very paper-worthy concept if someone's interested in it. And that is, we're over-leveraging through the use of contracts, IP rights. So we are, through the use of contracts, taking away rights that you otherwise would have, or sometimes providing rights to third parties that they don't have because of how lawyers draft things. And if you were a lawyer writing any contract, but particularly an end-user license agreement, in the best interest of your client, you would naturally, and you'll find this when you get into practice, you will grab every piece of territory you possibly can, including territory that your client doesn't actually own. Because for you to feel good about your job as a lawyer, you have to feel like you've given your client the maximum rights. And you're going to err on the side of caution and give them rights that they may or may not have, just to ensure, just in case they do have them, that they're covered. Because what happens if you don't give them rights that they could have had or could have had down the road? So the whole process makes all of this very, very difficult. The rub is that these are consumer contracts, so you're taking rights away. To protect your client, you're taking rights away from the user, from the gamer. Sometimes that's good. I'll hopefully show you where it's good, but I'm going to start a little bit with where it's bad. Things like this, well worth reading this article. And my apologies, I will, on the version I post, I'll make sure that the link is actually there. It's though very easy to find. This is how in the Kim Kardashian game, some people think that they are posting to a fake Twitter within the game, because there's a fake Twitter within the game, and you can mistake it to post to a real Twitter, which will then say, and you can decide whether this is a problem for you or not, I am on the Kim Kardashian game to the whole world. Now, you may or may not want people to know that. But you see this piece, and there's a question as to whether it's intentional or not intentional, and Mavis, in fact, I don't know if she'll address this exact example, but you'll understand the dynamic of how this comes to be. The developer said, no, that's not, it's just an accident, very few people are misunderstanding. But the import of this is that this ends up being covered in the end-user license agreement. There isn't that, if you read your end-user license agreement, you will see that you've given them various permissions that arguably include doing this to you, whether intentional or not. Doesn't mean legislation. Now, the flip side is that sometimes things are done, and I'll put this in the middle ground. EA cracks down on FIFA virtual currency sales. We don't want virtual currency within FIFA. They banned hundreds of thousands of accounts. On what basis did they ban these accounts? You bought the game, the end-user license agreement. So we're going to go through the process. Very similar example, and you have to decide for yourself: are these infringements on freedoms, or are these protections of the community and the player? These are not simple questions. but they're all empowered by the end user license agreement and terms of service. They're contractual. And next week, we'll get into the discussion of whether they really have to be in a contract. So just briefly introduce that question to you. Could you do this in other ways? And then, I mean, this was a major controversy outside of gaming. This was Facebook using its data to do academic research where they did A/B testing on certain data that people had, but were manipulating the data that people got for that reason. So you got something that side of the room didn't get, and they compared your reactions without telling you. And then they published it in an academic journal, and a whole bunch of people went, whoa, how do you get to do that? How do you get to change the data I see in order to see what my reaction is going to be? And again, discuss it and debate it. No one sued them, to my knowledge. Why? Because read Facebook's end-user license agreement. Except nobody does. And then this is kind of way outside of video games, but it sort of shows you how dominant, but I'm going to call it the cult of the end-user license agreement actually is. This is a Canadian case. You might have seen this in criminal law. You may not have. Godbout. And Mr. Godbout received a courier package that had drugs in it. Apparently drugs aimed for him. The courier package had somehow been sniffed or suspected by the courier company. They opened it. They found the drugs. They notified the RCMP. The RCMP arranged for the continued delivery of the package to Mr. Godbout, and then arrested him. And he said, under the charter, I have a reasonable expectation of privacy. People shouldn't be opening my packages. This taints the evidence. And this is a pure criminal case. And the court said, no. The courier company had contractual terms that said that without notice, they may, in their sole discretion, open and inspect any shipment and notify the government, et cetera, et cetera. One problem with that. Godbout was the recipient of the package. He had not agreed to any contractual terms and conditions. And it was still interpreted against him as if he had. We have a real contractual cult when it comes to this stuff that worked very well in the 1850s and doesn't work so well in a digitally interconnected world. So, we've arrived at the core of, this is the belly of the beast, if you're wondering what that is. So, I wrote this, obviously. I am agreeing, I am not reading what I am agreeing to. I am doing this thousands of times. Each document I am agreeing to and not reading is different, often quite different from every other document I am agreeing to and not reading. And this is what we're doing every day. Each of you, law students, you're doing this. You know better. I know better. I know way better. I teach this, and I do it all the time. I don't read these things, none of them, unless I have to read them for this class. Now, different kind of warning. What you're about to go through with me, and I will keep it really short, is incredibly dense and boring and difficult, and that's the point. Because this is the stuff you're not reading. Davidson, you've heard about Davidson a whole bunch of times. This is the BattleNet case that you're probably now hearing about for the third time or fourth time. So there's a Friends of the Court brief filed. You know, I'm sure none of them are really very good. You know, teachers of IP law in U.S. law schools. A pretty significant group of people. So their brief to the court, which was unsuccessful, argued that as far as Blizzard's end-user license agreement prohibited permissible reverse reverse engineering that was permissible by copyright law, Blizzard's EULA should be preempted. So their argument, the law professors of IP argument, was that where there's a conflict between IP law and contract law, IP law should rule. This is the core of what the court disagreed. So this is where the cult of contract comes in. Contract law rules. So all those things we're reading, all those things we're not reading are actually terribly important. We're not reading them because we'd like to think that they're not that important. But they are. And yes, I put it in Times New Roman on purpose to make it more difficult to read. So yes, I'm manipulating you. But just try to read this. And these are just the excerpts of the clauses that were relevant in the Blizzard case. And I've even gone to the trouble of highlighting in yellow the specific words that were the core of the decision. This is just a small part of the end-user license agreement. Now here's a gold farming case. Now this is, you look at the moral issue, and the first one is a modding case, or a quasi-modding case, because it was a technology, not a creative mod, but it was a technology mod. This is where Blizzard ostensibly goes to defend gamers, or at least gameplay, and says we don't want gold farmers in our products because it unbalances the game and it affects other gamers. And they succeed, and they do that based on the end-user license agreement and terms of use, and the offender shuts down its business, and the case is settled by consent order, and here's the language. And it's not the same language, obviously, and these are different parts of the contract, but one thing that you know, and I'll just tell this to you anecdotally, because you know it anecdotally, is that on all the end-user license agreements you signed, not all of them, but on many of them, you get updates. Before you can kind of rejoin our service, we need you to agree to our updated end-user license agreement, which you equally don't read. I don't know how much you learn about litigation tactics, but I'm sure you figured this out, that one of the tactics involved in the real world is flooding the other side with discovery documents. Query, is this a version of that? Do we have to, think about this before next week, do we have to have 20-page end-user license agreements? And does each end-user license agreement have to be different from every other? And maybe to be profoundly troublemaking and post-constructionist about it. Why can't I have my end-user license agreement and the companies have to agree to that if they want? We clearly have the technology. And maybe that's a brilliant app somebody should come up with. Total reversal. You want me as a customer before you get me as a customer. Here are my terms. Do you agree or not? This is the MDY case. And again, I want to give you different perspectives. This is the perspective of the Electronic Frontier Foundation. The court addressed the critical legal question of whether magic words in an, I love the way they do this, magic words in an end-user license agreement slapped onto a consumer product can turn buyers into mere licensees. And of course, the court said they can. And that's what the EFF objected. So this is that question that I alluded to last week. Why, when you, in the old days, bought a CD in the CD store, there was no, you bought it. It belonged to you. There was intellectual property on it. That was dealt with according to the Copyright Act. So if you made a zillion copies and you distributed it, that was a problem because you breached copyright, but you own that physical disc. And if I wanted to sell you my CD collection, you could use it as CDs and play the music, or you could use it as coasters if you want. But there is a right of first sale in law that allowed that to happen. But there isn't, there could be, an end-user license agreement could allow resale, but almost none of them do. And they end up being, it's structured as a license agreement, not a thing that you can sell. Not as personal property, but as a license agreement where the residual property actually belongs to, in our case, a video game company. And more words. You can look at these at your leisure. There's no leisure in it. I'd love to say there's something profound, but I could read this to you. You agree that you will not modify or cause to be modified any files that are part of the program or the service, create or use cheats, bots, mods, and or hacks. Basically, you're prohibited from everything that the lawyer can think of prohibiting you from, that the company wants you prohibited from. Some of these will allow you to make mods, some of them won't. Again, no two of them are alike. The Video Game Company Industry Association has, to my knowledge, never put out a suggested common form of end-user license. And I don't understand why not. I think it'd be helpful to everybody, including the companies. Now, the people it's not helpful to are the lawyers. Because lawyers are drafting this stuff, and so thousands of law firms are drafting thousands of different iterations. So, to some extent, I'm arguing against interest here. Blizzard and Marshall. This is a hacker group case. Again, different language, and it's very interesting because you'll go through the Blizzard cases and you'll see there's different language from Blizzard on the same things at different points in time. And again, reading all of this is something you read on your own because it all flows. The point is the court found in favor of the contract every single time. And footnote to that, the court tried to preserve copyright law every single time. So when it came to Glider, you, as a gamer, if you used the Glider bot, you breached the contract, but you did not breach copyright law. That was the court's finding. And the damages by you using, as a consumer of the bot, and they never went after any consumers, was minimal. They went after the makers of the bots. And they used the contract, the end user license agreement, that's really a consumer contract, against the makers of the bot, because to make the bot, you had to have access to the game. To have access to the game, you had to sign the end user license. You had to agree to the end user license agreement. That's how that worked. None of these cases really go after consumers. Where they go after consumers is only where they're doing something on the website. That's fine. So this I do want to show you because it's in Marshall and it's in the agreement there. Because this sort of sets up Mavis's talk a little bit. When running the game may monitor your computer's random access memory for unauthorized third-party programs running concurrently with the game. The game may communicate information back to Blizzard. So they're doing it for this purpose, but they are monitoring your RAM. And they're taking that information back. This is how big data gets aggregated. And I wanted you to see that. Like, there it is. It's right there. There's the permission that I guarantee you never read. This is Werner and Autodesk, and this is kind of the case that I said there was one non-gaming case. This is a non-gaming case where copyright law, where contract was preferred to copyright law. This was a software license agreement. And Werner wanted to sell the software that he felt he had purchased. In fact, he had licensed to someone else. He wanted to resell it. And the court said, no, the first sale doctrine that exists under copyright law that would allow you to resell does not apply because the contract says it doesn't. Simple as that. Contract supersedes. So this makes things very complicated because we spent the first half of the course acting like copyright law mattered. And even with the post-structural discussion, we're acting like copyright law matters. And if we don't address the contract issue, none of it really matters. iRacing, just want to see this. You can see the actual language they actually put in. Derivative works based on NASCAR 2000, their previous game. That's exactly what Tim Robinson did. He breached that. And that wasn't a creative context. It's the one troubling case, as you know. And again, this is a really good example. And you have to sort of parse the words here, but he breached the EULA. And only $1 was awarded. Why? Because there was an injunction. The whole point of the case was an injunction against him distributing his molecule. So the $1, it wasn't the damages that mattered. It was preventing him from distributing the molecule. And that's what they got. Here's, again, you can look at these, and this was a statement of claim where plaintiff claimed that he had become psychologically dependent and addicted to playing Lineage 2, which is a game. You can replace that with any number of other games. And never received any warning about that. And the court found that the end-user license agreement applied, and there was a waiver and limitation of liability in the end-user license agreement that applied to the negligence claim. Anyways, this sort of goes on and on. Lovely lots of drafting tips in here. This is not a EULA drafting tips class, but in effect, if you read these, you'll see lots of things that are worth seeing. Gold farming case. This one is really interesting because this is not brought by Blizzard. This is brought by a gamer against the gold farmers, saying you're interfering with my game, and relying on the end-user license agreement that the gold farming company had agreed to with Blizzard. So I'm a gamer. I have signed an end-user license agreement with Blizzard. Blizzard has agreed to an end-user license agreement with the gold farmer. I sue the gold farmer, saying I'm relying on Blizzard's agreement with you that you will not gold farm, and you are gold farming. And the gamer succeeds. The fly in the ointment is that the principle that the gamer succeeds on was rejected in MicroStar and ForbGen. That was where the company aggregated a whole bunch of Duke Nukem level mods and put it on a CD and sold it. And they tried to argue, well, you had an agreement. You, the makers of Duke Nukem, had an agreement with these modders that allowed them to mod. I'd like to take the benefit of that agreement. And the court said, no, you don't get the benefit of that agreement. But when it's the consumer, and it's hard to argue with this from a gamer perspective, where it's the gamer consumer, apparently the gamer consumer can take advantage of that third party. Or in law school, we get to point out contradictions in cases. This Texas Hold'em poker, when poker became big, every game company started making poker games. This is Zynga trying to stop them. Again, using the contracts. This is similarly, these are just sort of rip-off games. So in a sense, a good use of end-user license agreements, if they're really necessary. And here's the terms of use apply. One more bonus case, Blizzard and Ceiling Fan. Blizzard's motion for summary judgment granted against bot makers on the basis that the defendants knew of the terms of use and then user license agreement. next week, I know that Alfie may not be a movie of most of your generations, and in fact, when I went for the song Alfie, something very different came up, which I guess is a different meme. But I love the lyrics because they apply completely unintentionally to end-user license agreements. When you sort it out, Alfie, are we meant to take more than we give? And that's kind of the core thing that's going on here. And we will kind of do end-user license agreements and contracts part 2 and concentrate a little less on the contractual terms. I just wanted you to see how bad, difficult, challenging, unique each of them are and what you're agreeing to. And next week we will actually look at the effects, the real effects, the social effects, the effects on what games you actually get to see and don't see, get to play, don't get to play, that these agreements, what do these agreements really end up doing over and above the simple stuff, which is what we talked about tonight. Any questions? Yeah.
Hi, I'm Mavis, Dixon, and I work for a company called Ayobo, which makes video games for, well, less video games these days and more applications, but gamified applications for people who have chronic health conditions. My background is a lot of things, but part of what I do at Ayobo is do some of the behavioral economic analysis or thinking in some of our designs. So I gave a talk a couple of months ago at the Fellini Summit that had information on the neurotransmitters and various kinds of chemicals that we use when we make decisions. And so my talk is in part shaped by that. So if John says there's a connection to EULAs, I trust you guys to find it. My talk at this point is really about how we're wired to play and how we, as designers, translate those impulses into structured behaviors.
So let me do 2 things.
Yeah.
First, let me defend my connection to EULAs. Now, do you want to be tethered that way?
Whoa.
Or do you want to put that?
I guess I better put that on.
And that is only to say that when you think of the interaction with the consumer that allows you to change their behavior,
right.
It's the consumer allowing you to change their behavior and agreeing to it. The only legal means that that agreement, or the legal means that that agreement takes the form of is a contract, the end user license agreement.
Okay,
So there is permission, and we permit a lot of things to happen, and there is, what you guys do is amazing and wonderful, and for humanity, the same principles can be applied for less good purposes.
Yes, that's true.
So, but whether they're being applied for good purposes or bad purposes, the permission is coming from the contract.
True.
So now the one unintuitive part of this is you have to pull towards yourself to go to the next slide. So it's not this, it's this.
Okay. So I don't use this.
No, you use. There you go.
Whoops.
And
then push it away to get back.
push it away to go get back. And
Okay. So as I mentioned, I work for Ayobo. Ayobo's name comes from two ancient games. Anybody played Go? Excellent. It's an excellent game, one of the oldest games in the world. And Ayo is another word for Mancala. Anybody played Mancala? Great. So Mancala, the picture on the left is from the Temple of Study, which was built by Ramses II. And it was played by priests while they were out waiting for the clouds to clear from the skies on the top of the temple. It's a game where you move marbles or stones around a tray, and it's a very simple game. It's a very ancient one. And Go is a simple game that involves just flipping pixels. So flipping from black to white and taking your challengers points away from them, and it's also known as a fellow. And Go is a game that we like to talk about because often when people come to us as clients, they're very interested in very complex, immersive environments, and they don't realize that we're wired to respond to very, very simple stimuli, and Go is probably the simplest game you can imagine, but it's one of the few games that has not yet been beat by computers. Human players are better at Go than computers. So we start with this slide because games are an extension of play, and we're naturally wired to learn through play. By showing the game of hide and seek, we are reminding you that our survivalist species has come from this ability to learn through learning about dangerous situations, how to avoid predators, how to seek prey. We have learned that through playing it in risk-free environments. So, you know, if this little girl, the very first time she had to avoid a predator was in a high-risk environment, she probably would have been paralyzed with fear, but through repetition of a behavior in a non-threatening environment, she learns the skills she needs and becomes a competent hider, or she may be a prey seeker, like the little boy is being here. She's also learning about the social interactions that are going to shape her life. So is this guy going to be a good provider? Those kinds of questions are all part of what we're wired to learn through a very simple mechanism.
Do you want me to do it?
Maybe. I'm getting the hang of it, I think, but it's...
You can also just signal me if...
Well, we'll start there. So really, we have this impulse to play, and it comes from our chemistry. And what games are a constraint-filled space that intensifies that experience of play. So you can turn your attention using games. And if we think about very open-ended experiences that don't have constraints around them, they sometimes have playful elements. And so the definition of a game is a playful experience that has constraints. So there's usually rules. That's the constraint system. There's some sort of win state that you're moving towards. There's a feedback system that gives you a sense of whether you're going to make it or not, and voluntary participation. So you can have rules in a work situation, and it won't feel very playful, but you can actually volunteer to participate in something if you think it's going to be fun for you. So that agency is a really important element of games. For example, you know, let's think about the game golf, right? If you had a functional thing that you wanted to accomplish, you wanted to get a ball in a hole. You could walk, you could carry the whole ball, you put it in a hole. You put a whole bunch of constraints around the game of golf to intensify the playful experience of it. You make somebody hit a tiny ball with a long stick over a lot of landscape, and the end goal is to get it in a hole. That is only fun if you do it voluntarily. So if somebody says, okay, your job is to get 18 balls in that hole, and you have to do it, and you have all of these barriers between you and that hole, it's no longer fun.
Just like law school, then. The second example.
There's a lot of things in life that we talk about being games or playful that actually are not. And in fact, there was a case of somebody using gamification in a work setting where the employee sued because it was actually a painful experience to do their jobs. They had a leaderboard where they were being given points and measures, none of which was voluntary, and it was a shaming experience for them, and they ended up suing them.
And you say that just the day we put badges onto the website for this. Thank you very much. If there are any complaints, let me know. We'll disconnect the system. But you know, gamifying video game law's website seems to fit, and that's why UBC wanted to do it. So
good. Well, we'll talk a little bit about gamification. So, so as I mentioned, this is a definition by Bernard Suits. It's probably the shortest one of the game, but instead of golf, in this case, it's hockey. But the word voluntary is centered to that. Unnecessary obstacles is the playful element. So place in the science of figuring out what is a playful experience, because they were the first environment in which you could get really concrete feedback on where people dropped out, what people found interesting, what people would do over and over and over again, like Pigeon in the behavioral psychology experiments, what they would continue to tap at. And so there was a real science of behavior evolved through video game design. So video game designers were not interested in the psychology. They were just interested in keeping people in their games. So they were looking at telemetry, which is a remote monitoring of feedback and inputs. And and data mining, which is telling them, okay, somebody played this action 17 times, but they never went into this space, or they dropped out of the game routine here. That kind of information allowed them to formalize game development into specific mechanics. So they're very discrete pieces that if you go to the gamification blog, you'll see, I think 150 of them or something like that, that are broken out and identified, and you can take a little visual of what they might be. So badges, for example, would be a game element, levels, boss fights. There's a whole zillions of them. I won't go into them all, but they have all been looked at very analytically by the video game industry and used very, very intentionally, often without any kind of insight into the psychology behind them. So what I'm going to do today is talk a little bit about the psychology behind them.
Can I just add one footnote?
Yeah.
The gathering of that data is permitted under the end user license agreement.
Yes.
There is nowhere else, there's no copyright law, there's nothing that allows for that data to be gathered by the gaming company or the digital media company except the contract.
Good point. So dopamine is the central player in most of the chemical reactions going on when we have these playful experiences. Dopamine is triggered by stimulus, so there's something that you're in autopilot, your brain is not really conscious of a particular stimulus, and then something deviates from the norm and that draws your attention. So for those of you who have been driving for a while, often you can be in that autopilot mode while you're driving along, and then a deer appears on the side of the road. That's considered a deer stimulus. So then you have to make your brain go into another mode of attention, and you are in that mode of attention. Dopamine is flowing through you. You're starting to get other chemicals responding, and you're anticipating what you're going to do. So you have to make a decision about the action that you're going to take. You make a good decision or a bad one, and you get feedback. So that dopamine loop is actually part of what we call a habit loop. So you have the trigger, you decide whether to act or not, you get feedback on your action. That feedback will then allow you to decide what you're going to do again. Next time you see that trigger, or perhaps you haven't resolved the situation successfully. And that is the core of a persuasive technologist, B.J. Fogg's model. And so here he has this action line, right? So the action line's here, obviously. When things are hard to do, the trigger has to be incredibly strong, the motivation has to be strong for you to cross that threshold. Or if they're easy to do, it doesn't have to be much, you can just do it. So he's all about designing things that fall down into this area down here. Things that are consistently difficult, so there's a level of uncertainty about whether you're going to be able to accomplish it, and you want to achieve this, and you are positively engaged, can be very absorbing. And so that is where there's a researcher named Pichen Mahai who coined the term flow. Flow is a very concentration-rich, time-unbounded experience. But we spend a lot of time in our designs down here with habit. So we're not in the flow space, and we'll talk more about flow in a minute. But in our work at iYoga, what we're trying to do is habituate behavior. So we try and break down health problems that are big into small little things that people can act on easily and repetitively to improve their health. So our design is down there.
Where would, in your opinion, Candy Crush be on that curve?
Candy Crush has a mixture of things on that.
Yeah,
group.
I think it'd be interesting for you to just, I know it's just an opinion, but I think it'd be interesting for them to hear.
Who plays Candy Crush? Who has played Candy Crush and deleted it from their phone? So, actually, it's interesting. There's a lot of behavior in Candy Crush is down here and easy to do. There is this aspect of sorry, my head. There is this there's a I have a slide, but it's not in this deck. That's the boss fight slide. So Candy Crush is a classic case of tension release game where you resolve, your dopamine is high, but you get a flush of endorphins because you've responded correctly, you had a positive feedback message, and it kind of goes along fairly evenly while you learn different skills like avoiding the chocolate and stuff like that. And then you get one level where everything you've ever learned is time-boxed with time. And that's a boss fight. So that's a really intense gameplay experience that just has a whole ton of chemicals in your body responding, not just dopamine. And then when you resolve that, which can take you 100 attempts if you don't spend money in the game, you have a great relief and then you go back to the low level, easy to do stuff. So Candy Crush is a designed game to not do too much of that torture, but I'm getting ahead of myself a little bit, but torture is a big part of the game.
I'll let you go now.
So I did want to talk about flow, though. So flow is, the reason I have Goldberg variations up there is because there's great videos of Glenn Gould. Maybe you guys are all too young to know who Glenn Gould is, but he was a famous Canadian pianist who hummed along with himself while he played the Goldberg variations. And if you ever watch a YouTube video of him, it's a picture of somebody in flow. I mean, the guy's just completely in the moment. Time is gone for him. He is concentrating utterly on the task at hand. This loss of self-consciousness is very important. He would be in these concerts and singing out loud to his songs because he was so lost in his own experience. So flow is very much associated with video games. It is also, but Cheech and Mahai, by the way, who coined the term flow, calls video games junk flow. Just so you know.
Yep.
So the experience of flow is something you can have in many, many spaces. It is a very, very rich psychological state where there's a lot of mixtures of neurochemical reactions going on. So we talked a little bit about dopamine. This is the attention and anticipation neurochemicals. Serotonin is the relaxation and kind of is a big part of flow. Actually, it's a very open feeling. Serotonin is associated with falling asleep. It's associated with satiety, so that you know that you feel full. You can't. It's not manufactured in your head. It's actually manufactured in your gut. It's a product of food. Tryptophan. It's a tryptophan. A lot of people think of tryptophan in turkey, but tryptophan is the source of serotonin. Endorphins. That's a short form for endogenous opiates, and endorphins are the flip side of dopamine. And when dopamine goes into time-box stressors like cortisol, you end up with a relief from those with endorphins, so that tension and release. And then oxytocin, which is getting a lot of talk these days, some of it very confusing. It's known as the cuddle hormone. It is affection related, and it is also increasingly understood to be what I'm starting to call the us and them hormone. I have to enunciate that because I said that once in a talk and my friend said, what's the us and them hormone? But the us and them hormone. So oxytocin is something that is very much about bonding, but it's also about the other. So when you think of it as the cuddle hormone, mother and child, also think of it as the mother-bear hormone. So it is stimulated by shooting in video games. It is stimulated by bonding in alliances in video games. It is stimulated by opposition in video games. So there's a guy named Dr. Zach who has a TED Talk around it. He has a book called The Moral Molecule that I'm currently reading. But he is somebody who you will also find on Bad Science as somebody who oversimplifies oxytocin to be the moral molecule. When really it's about many, many more things than that. But all of these things interact, and there's a wonderful psychologist named Nicole Lazzaro who talks a lot about these elements in video game design and persuasive technologies. And I'm going to talk more about her 4 keys of fun later. So why do I put this screen up? I thought about taking it up for this presentation, but I thought it would be good to put it in there because, really, I'm on the user experience side of the video game design. And so when people think about user experience, they're often talking about simplification, taking out complexity, and making things really, really strong calls to action, clear paths to an end outcome. Picking up the ball and taking it and putting it in the hole is good user experience design. But why do we sometimes not want that? And this is where games and play come in. So this is a flow diagram for actually spellcasting and magic. And a good example of things that we do for fun. So if we're going to talk about using games for engaging people, you actually have a better experience of engagement, the more barriers you put between that person and the outcome if it's a gamified experience. So somebody will remember you longer, somebody will come back to the site more frequently, somebody will engage more in a more sustained way with their peer group if they're doing something with a lot of steps between them and the outcome. So sometimes that makes sense, and sometimes it doesn't make sense. Sometimes, particularly in my space, where I'm working in the healthcare space, we do not want to put any steps between somebody and their end outcome. But if these factors are in place, then it would be an appropriate situation to use a game or gamification. So to go back to the video game law website.
Yes.
As long as the gamification is outside of somebody submitting their
Yes.
Their results or something, it's outside of a core action that you're asking them to do.
But
it's
a very interesting point, because I was asked, do you want a game leaderboard? And because UBC's thinking of buying this game leaderboard functionality and this very talk, because if there is one, I'm going to say people are going to have to opt into it if they want to play against each other, or otherwise it won't exist. Like right now, if you get a badge, I don't even see it. Only the person who gets the badge sees it.
Right.
And it's totally outside the marking scheme of the course.
Right.
So there's nothing, and you can look website page 2 at the bottom. It's a little bit buried right now, but that's where all the information is. But as you ramp up, you could do some really weird things with it if you start pitting people against each other.
You sure could.
And law school's really bad at that already, so I don't actually want to make it worse.
Well, and leaderboards are shown to be demotivating for 90% of the people. The only people they're motivating for are the people who are in the top 10. Which is why or top 10%, which is why, Scrabulous or any of those peer-to-peer games, they don't show you the whole leaderboard. They show you where you are relative to your closest peers in the game. So if you're playing a game where you can get, I don't know, I don't remember how Scrabulous works, but like let's say you get 43 words per minute or something, and your 2 buddies, one gets 46 and one gets 42. Then that's a leaderboard that will be effectively motivating. But if the best Scrabulous player gets 107 words per minute, you're not even close. No. It's not a good thing. So, anyway. I think I will skip this. I'll go with this. So this is Nicole Lazzaro, and she was the one that was talking about dopamine, oxytocin, serotonin, and endorphins. They map somewhat to her 4 keys to fun. So I'm going to talk about each of these. This is her incredibly complex map that you can download. It makes a lot of sense, and you should spend a lot of time looking at it, but it's too hard to explain in a single conversation. But we will, oops, maybe I will be spending time on there. I thought I had a whole bunch of slides on there. So I'll talk about it one by one. So with Easy Fun, you're talking about you're really talking about the emotional state of curiosity, surprise, delight. You are using techniques of discovery. So if you think of your phone, those games that you just use the accelerometer in the game, in the phone to like tilt things, make them bounce off of things, and they're just kind of goofy and surprising and delightful. They don't have any strong aim to them. Nicola Lazzaro uses the metaphor of bubble wrap, that there's something about the experience, the haptic feedback, finding Easter eggs, which are, things that are just unexpected that show up in your game. All of those are just easy, fun experiences. And in video games, they are positive, light emotions, and they're really, they're just elements of delight. On the opposite end of the spectrum is the hard fun. So the slides I had, it's too bad, I don't know what I did with them. But anyway, the slides I had, there's this great sculpture of Bernini's David. And he's got this face on him, like, it's really knuckled down, he's really tight lips, furrowed brow. That experience of frustration and concentration, that fiero that can turn into flow and relief, when you've done what you've got to do, that is the hard, fun experience. And that's actually probably what you talk a lot about, like the video games, Need for Speed, and all of those.
Destiny right now, for those of you who are playing it, right? Very frustrating. Very fulfilling. Very fulfilling.
So that hard, fun experience is what we often think of as video games. Usually the big console games fall into that category where you have a lot of strategy involved, you can mature deeply into it, and it's very, the full spectrum of emotions. There's often time-based elements to it that take you from just dopamine into full-on cortisol. So cortisol is when your body has stressors in it, and anything that's time-boxed, where you're racing against a clock to get something done, will introduce those stressors into your body. And then you have much higher level of uncertainty, so you're not likely to succeed at first. It might take you 100 attempts to get something, and then when you do, you get a phenomenal flood of endorphins. So that opiate flooding in combination with the anticipation and stress is a wicked combination.
Can I ask a question? And I hope it's not taking away where you go later, but if I purchase, so I'm frustrated, but I can purchase an in-game solution, do I get the same release?
You will get some release, yes.
Okay, some, but not necessarily the same. Has there been any research that shows?
That's a good question, but I'm sure that purchasing a solution will
get some of it, and it will be interesting to know how much of it, because that really does affect gameplay design in another way.
Yeah, and everybody is quite different. I think I had a slide in here that had a big fat caveat on it, which is everything I'm saying comes from the research where they're looking for significance in the tiny percentages. Not 100% of a population is going to respond 100% the same way time after time. It's subpopulations, subgroups within the population will respond in a predictable way to certain elements of the game. So there's hard fun, there's easy fun. Serious fun is when you layer on a level of meaning. And the photo I had for here is Andy Goldsworthy. Has anybody seen Andy Goldsworthy's art? He makes these environmental art projects where he puts a bunch of natural products together. It might take him like weeks or a long time. Or did anybody see the movie Where the Wild Things Are? And the woven nests that the kid makes with his dad, or the monster. These are things that are kind of like meaningful, repetitive, building kind of projects. They have a lot of rhythm to them and a collecting element. And in video games, these are shown as collection mechanisms often.
So Minecraft has a lot of that.
Minecraft is super, super, super on the serious fun side of things. Minecraft's an excellent example, yeah. So there's something incredibly satisfying about seeing the results of your effort over a long period of time. If you are, in most video games, you're amassing a certain amount of wealth in the economy or tools. That's the serious fun side of things. There's usually an element of giving of yourself in that part too, so something purposeful, that you're not just in the fun zone. Yeah, so those that serious fun part of it does have elements of dopamine, but it's a much more complex and rich mix of neurotransmitters in your system. So people fun. Now, Nicole Azara says that people fun is really one of the most addictive elements of games. So when you think of these massively multiplayer games, role-playing games, you almost always have a very strong social element in there. There's social obligations. We are wired to reciprocate. So if I buy you a coffee, you will not sleep properly until you have a chance to buy me back a coffee, right? It'll be an imbalance that we just can't live with, right? If I give a gift to you, virtual gift or not, maybe took me 5 seconds of my day and cost me nothing, you owe me something. You feel that, right? So my sons play League of Legends, and they will defy me because they do not want to let down their team. If they've started to play and they jam out, walk away, and go have dinner when they're supposed to, they will leave their team in a situation where they may get locked out of the game, and everybody's super pissed off, and that is so, so hard to say no to. It is the hardest thing to say no to. And so all of these video games that combine hard fun and people fun, you're locked in. They're like handcuffs. Be careful with them.
So can I just give you one? EVE Online. So EVE Online is that correlation of people fun and hard fun. Yeah. And boy, does it work.
Yeah.
And
really
it
works.
creates the greatest amount of havoc, in a sense, in the legitimate video game system.
Right, exactly. And so, when I was talking about oxytocin, this is people fun. So oxytocin is very ephemeral. It's a neuropeptide that's in your system. It's got a half-life of 3.5 minutes. It is very, very ephemeral. It is stimulated by all sorts of little light touches. Emoticons can stimulate oxytocin. Likes on your comments stimulate oxytocin. Everybody's different. What's going to stimulate oxytocin for you is going to be different from me, but it is just very easy to sustain engagement with something that is giving you constant hits of oxytocin. But oxytocin is not dopamine. It's a much lighter weight draw. So she has the words over here for people fun, amici and amiero. So amici is buddiness, and amiero is more of amorous, admiration and amusement. But there's a big one in there that she doesn't list there, and that's schadenfreude. So schadenfreude is a term where you're kind of gloating over somebody else's failure. And oxytocin is schadenfreude. When you feel that little hit of like, yeah, that is from oxytocin. So, and
EVE Online has got to be the biggest oxytocin game there is.
Yeah.
It just has to be. I mean, Halo will be up there. There's a bunch of others that will be up there. But I defy you to find one that's more oxytocin provoking than EVE Online, given your description.
Yes, exactly. So interesting recent research in oxytocin, so this is part of the big fat caveat, is that, you know, when there is, I'll try and remember roughly what the study was, but basically there was women who were not diagnosed with personality disorder as the control group, and women with diagnosed personality disorder as the experimental group. Both of them received an inhalation of oxytocin. So they were to write an essay about their mothers beforehand. They took a hit of oxytocin, they read, and they answered some questions about their mother afterwards. So normal people who don't have this diagnosis, their essays about their mothers and the adjectives they used afterwards grew with affection. The people who had personality disorders became virulent about their mothers afterwards. So there is no happy one-size-fits-all with oxytocin. It intensifies feelings of jealousy, it intensifies feelings of possessiveness, it intensifies negative feelings for those that are clients. So something to keep in mind is with these video games is that one person's experience of a video game is going to be very, very different from another.
So when we, just to presage where we're going with this, when we're talking about violent video games and social effects of them, you will see there are two groups. There's a group unaffected and a group that is perhaps affected, and lots of research showing these two groups, and it's it creates fascinating legal policy problems in terms of how you deal with it.
Yeah. Okay, so I'm going to talk a little bit about the researchers Daniel Kahneman and Eric Swertsky, who won the Nobel Prize for economics for their behavioral economics, and this is for their system 1 and system 2 thinking, and they started to notice that in psychology there was predictable cognitive biases. So I put this one up here as a little test. So a dress and a scarf cost $110. The dress costs $100 more than the scarf. How much does the scarf cost? So, that's not a word. I don't know what I've done wrong, but anyway, there is a impulse to answer the question with the most accessible answer, which would be $10.
Yes.
Right? So is that the answer most of you probably had come to mind? $10. So with that answer, the accessible answer of $10 is what Kahneman would call system 1 thinking, or thinking fast. We have an impulse to answer the question. The actual answer is harder to get to.